My name is Allan Hanley. Worked for the Bureau of Indian Affairs for 30 plus years in South Dakota, Montana, and Wyoming. I spent 3.5 years at the Lower Burl Reservation in central South Dakota. Then I moved to the Crow Reservation for 16.5 years as a rangeland management specialist. Crow Reservation is 2.2 million acres of mountains, desert, and rangelands, and it was a great experience. In 2002, I was fortunate enough to be hired as the rangeland inventory specialist for the Rocky Mountain region, and my supervisor retired, so I was selected for his position, and I retired from that position in 2013. Been working for INCA since 2013 on a part-time basis. So Indian Nations Conservation Alliance is presenting this webinar for educational purposes. Indian country conservation is fundamental to a healthy ecosystem and environment for Native Americans to protect and preserve their natural resources for future generations. These are going to be my discussion items. I will be discussing each of these session items. I will try to complete the webinar within 1 hour, and it's probably going to be less than that. You may call me or email me if you have additional questions. I will try to answer to the best of my ability. We're going to talk about laws, trust responsibility, the American Indian Agricultural Resource Management Act, and existing federal budget processes for tribal governments, planning and dealing with partners. The ground rules for the webinar. Most of the webinar's content is a result of internet search queries and personal experiences in conservation. The PowerPoint slide reflects my opinion. It will have in parentheses, or I will say, it's my opinion. This webinar does not contain legal advice. If you have a specific issue that you need legal counsel, please seek that advice from a qualified individual. I've had 30 years of experience with the Bureau of Indian Affairs, but I don't know it all. I've had the privilege to read the book by Don Miguel Ruiz. It's called The Four Agreements. The four agreements are: be impeccable with your word, don't take anything personally, don't make assumptions, and always do your best. I've purchased copies of this book for my 2 oldest grandchildren, and I've given them to relatives for graduation presents. It's a great book. It's a short read, but it's very powerful. What is a law? A law is a system of rules that are created and enforced through social or governmental institutions to regulate behavior. It has been defined both as the science of justice and the art of justice. Law is a system that regulates and ensures that individuals or a community adhere to the will of the state. The basis for United States law is a common law that was developed in England, brought to the United States by the English colonists. Laws are searchable. 25 U.S. Code, Chapter 39, is where you can find the American Indian Agricultural Resource Management Act. What is a regulation? It is an official rule or law that says how something should be done. It is a bureaucratic interpretation of congressional intent. After the regulations are drafted, there is a comment period of 30 to 90 days. The bureaucrats rewrite the regulations based on public testimony and comment. The regulations are reviewed by several federal agencies to assure that there isn't unfunded mandates and liability to the federal government. After the review, the president signs the regulations. We started developing the regulations for the American Indian Agricultural Resource Management Act in 1995. We had them pretty much all drafted, and then a decision was made that a higher level that we were going to separate it from leases and and include grazing permits. The original decision was just to have tenants and then have characteristics for leases to mirror what the grazing permits are now. But there was too much, there was public comments that wanted it to continue with the grazing permit system. So we went back and rewrote the regulations to include agricultural leases and grazing permits. And we finished the final regulations, drafted the final regulations in 1999. And before President Clinton left office in 2001, he approved the regulations for ARMA. Federal government, tribes, and states. Congress passes the law. Federal agency writes the regulations. Tribes, states, and citizens can object to the regulations by administrative appeal or by filing suit in federal district court. The court can rule in behalf of the tribe, state, or citizen, or the federal agency. If a tribal member or tribal government has standing, an administrative appeal can be made to the federal decision maker, or a case can be filed in the federal district court. Standing means that the individual or tribe's rights, legal entities, or businesses will be jeopardized by the federal decision.
Unknown caller.
Sorry. I think it was a scam. Executive orders. In, excuse me, I think in 1994, President Clinton signed the government-to-government relations executive order. United States government has a unique legal relationship with Native American tribal governments as set forth in the Constitution, treaties, statutes, and court decisions. The USDA has the following description of their government-to-government relationship. U.S. Department of Agriculture and federally recognized Indian tribes share the goals of developing sound agricultural production services, enhancing food safety, improving nutrition and health through food assistance and nutrition, education and promotion, managing and protecting the United States lands and natural resources, and working cooperatively to ensure that American Indians and Alaska Natives have full access to the programs and services of the department. The Department of Interior also has a discussion on their government-to-government relationships. Through this policy, the department strives to strengthen its government-to-government relationship with Indian tribes and begin consultation. This policy reflects the Secretary's commitment to consultation with Indian tribes, recognition of Indian tribes' right to self-governance and tribal sovereignty, respects Indian honor tribal treaty and other rights, and strive to meet the responsibilities that arise from the unique legal relationship between the federal government and Indian tribal governments. Trust responsibility. The federal Indian trust responsibility is a legal obligation under which the United States has charged itself with moral obligations of the highest responsibility and trust toward Indian tribes. I apologize. I am reading my notes from my phone because my printer doesn't work. And so you'll hear phone calls and other interruptions. Chief Justice John Marshall's ruling in Worcester versus Georgia. From the commencement of our government, Congress has passed acts to regulate trade and intercourse with Indians, which treat them as nations, respect their rights, and manifest a firm purpose to afford that protection which treaties stipulate. All these acts, and especially that of 1802, which is still in force, manifestly consider the several Indian nations as distinct political communities having territorial boundaries within which their authority is exclusive, and having a right to all the lands within these boundaries, which is not only acknowledged but guaranteed by the United States. The Cherokee Nation then is a distinct community occupying its own territory with boundaries accurately described in which the laws of Georgia can have no force, in which the citizens of Georgia have no right to enter but with the assent of the Cherokees themselves or in conformity with treaties and with the acts of Congress. The whole intercourse between the United States and this nation is, by our Constitution laws, vested in the government of the United States. The act of the state of Georgia are repugnant to the Constitution, laws, and treaties of the United States. The trust corpus is Latin for the body. This term refers to all property transferred to a trust. No matter what the type of trust, a trustee has what is called a fiduciary responsibility. This means that the trustee must use the utmost care and loyalty when managing the trust and cannot use it for their own personal gain. The trustee is legally required to work in the best interest of the trust and its beneficiaries. The accounting for trust funds must be accurate, and the trustee must use prudent investment standards, which means investing the money responsibly. The first discussion of Indian tribes is in the U.S. Constitution, which was ratified in 1788. State delegates met at the Constitutional Convention in Philadelphia. The debate over the idea of a strong central government would continue until September 17th of 1787, when the Constitution is narrowly approved. In June of 1978, New Hampshire became the 9th of the 13 states to ratify it. The Constitution becomes the law of the land. It was decided that the new government would take effect on March 4th, 1787, when the U.S. Senate met for the first time. The Indian Commerce Clause refers to the right of the Congress to claim plenary and exclusive power over federal affairs with Indian tribes. This clause is part of the Commerce Clause as enumerated under the Constitution. This clause empowers Congress to regulate tribal affairs. The next mention of treaties is in the Supremacy Clause. This clause imposes upon the state a duty to negotiate in good faith with an Indian tribe and authorizes a tribe to bring suit in federal court against the state in order to compel performance of duty. The Indian Trade and the Intercourse Act was a set of measures enacted between 1790 and 1847 to improve relations with American Indians by granting the United States government sole authority to regulate interactions between Indians and non-Indians. The sale of Indian lands to individuals or states was forbidden. It also restricted travel by non-Indians onto Indian land. And the federal government established trading houses near or on reservations. According to the Indian Appropriation Act of March of 1871, no longer was any group of Indians in the United States recognized as an independent nation. Congress directed that all Indians should be treated as individuals and legally designated wards of the federal government. Before this bill was enacted, the federal government signed treaties with different Native American tribes, committing the tribes to land cessions in exchange for specific lands designated to Indians for exclusive indigenous use, as well as annual payments in the form of cash, livestock, supplies, and services. These treaties, which took time and effort to finalize, ceased with the passage of the 1871 Indian Appropriations Act. declaring that no Indian nation or tribe would be recognized as an independent nation, tribe, or power with whom the United States may contract by treaty. The statute also declared an obligation of any treaty lawfully made and ratified with any Indian nation prior to March of 1871 shall be hereby invalidated or impaired. The Dawes Act was amended in 1891, in 1898 by the Curtis Act, and again in 1906 by the Burke Act. This act was named for its creator, Senator Dawes from Massachusetts. The objectives of the Dawes Act were to lift the Native Americans out of poverty and stimulate assimilation of them into mainstream American society. Crow Reservation was part of the Dawes Act. Adults got 320 acres, 160 acres. Their heirs or children received 40 acres to 160 acres. Next big congressional Indian law was the Wheeler-Howard Act of 1934. It's the IRA, or the Indian Reorganization Act. This act secured certain rights to Native Americans, including the right for tribes to organize governments and corporations. It stopped the allotment of land and returned unsold surplus land that was open to homesteading to non-Indians back to the tribes. The Indian Self-Determination and Education System Act of 1975 authorized the Secretary of the Interior, the Secretary of Health, Education, and Welfare, and some other government agencies to enter into contracts with, make grants directly to federally recognized Indian tribes. Tribes would have authority for how they administered the funds, which gave them greater control over their welfare. And this started the self-determination phase of the United States government, which continues today. Another is in NEPA, or National Environmental Protection Act. Promotes the enhancement of the environment and established the President's Council on Environmental Quality. So part of the regulations 40 CFR Part 6.103, the responsible official will coordinate with the NEPA official on resolving issues involving EPA-wide NEPA policy and procedures, including the addition, amendment, or deletion of a categorical exclusion and changing to the listing of the types of actions that normally require the preparations of an EA or EIS. So the tribes have the authority to modify the NEPA conditions within their political boundaries, as well as the states and local governments. Congressional Conservation Acts, the Soil Conservation Act of 1935. On this date, as blistering heat sapped the American West of much needed moisture, President Franklin D. Roosevelt signed into law a bill protecting land resources against soil erosion. Throughout Texas, Oklahoma, Kansas, Colorado, New Mexico, and the Dakotas, during the early 1930s, high winds stirred the arid soil, loosened after years of rapid homesteading and commercial agriculture. Hundreds of dust storms ripped across the southern plains during 1933, a prelude to the major storm of May of 1934, which whipped an estimated 350 million tons of earth into the sky, trapped people in their homes, suffocated cattle on the plains. Dust fell like snow in Chicago and the eastern cities. Sailors on ships 300 miles off the Atlantic coast swept Kansas soil from their decks. Similar storms plagued America's center well into 1935. Unlike the ecological forces that work on the plains, John Marvin Jones of Texas explained the bill is simple and easily understood. Bill sponsor John Dempsey of New Mexico, whose colleagues described as a soil erosion enthusiast, argued that the measure was of national interest and therefore vital. John Nichols of Oklahoma, whose state dust storms hit particularly hard, noted that in uprooting its topsoil, the United States had been living in a fool's paradise with respect to the security of its most basic asset. The New Deal, Congress passed the bill. So now we're going to start talking about the American Indian Agricultural Resource Management Act. It was amended in 1994 just because there was some confusion on some terminology. Congress finds and declares that the United States and the Indian tribes have a government-to-government relationship. The United States has a trust responsibility to protect, conserve, utilize, and manage Indian agricultural lands. Indian agricultural lands are renewable, and it's to enhance Indian self-determination, improve the social and economic well-being of Indian and surrounding communities. Carry out the trust responsibility of the United States promotes the self-determination of Indian tribes. Identified tribal goals and priorities for conservation. Authorize the Secretary of Interior to take part in the management consistent with the trust responsibility of the Secretary and with the objectives of the beneficial owners. Could be a tribal landowner or the tribe. The law does not say VIA's goals and priorities. The purpose of the law is to promote self-determination of Indian tribes and their tribal goals and their priorities. Indian agricultural lands means Indian land, including farmland and rangeland, production of agricultural products, and Indian lands occupied by industries that support the agricultural community. Indian tribe means any tribe, band, nation, pueblo, or other organized group or community, including any Alaska Native village or regional corporation. So when people say it doesn't include Alaska, it does. Indian tribes should designate their Indian agricultural lands by resolution, ordinance, or utilizing the ARMP. We're going to talk about the Ag Resource Management Plan in just a second. The term land management activity means management of Indian agricultural lands, preparation of soil and range inventories, on-farm irrigation delivery system development, and the application of state-of-the-art. Educational assistance and a direct assistance to tribally controlled community colleges. As we'll see further down, there really hasn't been any funding for educational assistance. Protect, conserve, utilize, and maintain the highest productive potential, to increase production and expand the diversity, to manage, protect, and maintain other values such as wildlife, fisheries, cultural resources, to regulate water runoff and to minimize soil erosion, and to enable Indian farmers and ranchers to maximize the potential benefits to them. So when this means the law, the section in the law right here. 10-year Agricultural Resource Management Plan, an ARMP. Tribe has authority to contract. The Indian tribes must request the funding. This should be in 2 years in advance so Congress can get it into the funding cycle. Usually this is by tribal resolution. The tribe does not want to contract the Ag Resource Management Plan. The BIA will develop the plan. This is right from the law. It doesn't say may, doesn't say, it says will. The tribe has discretion on plan contents. Like I said before, it's not the Bureau's goals. It's not, it's the tribal goals. And there's 3 years to complete the plan. The Secretary of Interior will adopt the tribal rule, as long as it doesn't conflict with the Secretary's trust responsibility. I added the words within the parentheses, the ARMP is a tribal plan. The BIA may request that the tribe completes the NEPA, but in Allan Hanley's opinion, NEPA is a federal agency responsibility. If the BIA wants the tribe to complete the NEPA document, then the Bureau of Indian Affairs must provide funding above the ARMP funding. As stated earlier, the tribe has authority to determine categorical exclusions, and that was in an earlier slide. So, you know, what it means to me is that it's a federal responsibility, not a tribal responsibility. And that's my opinion. The Secretary, my parentheses, Interior, shall conduct all land management activities on Indian agricultural land in accordance with the goals and objectives of the approved Ag Resource Management Plan, or in an integrated resource management plan, or in accordance with all tribal laws and ordinances, except when compliance would be contrary to the trust responsibility of the United States. Tribal governments can pass laws and ordinances to manage Indian agricultural lands until funding is received to complete the ARMP. It has been my experience that a cadre of Indian farmers, ranchers, landowners, and tribal staff should determine the Indian agricultural land goals, objectives, and standards. Draft ARMP is developed from the cadre's priorities for rangeland, farmland, both irrigated and dryland, wildlands with traditional products. After the draft ARMP is completed, the draft is submitted to the tribal council and tribal members for public comment and testimony. After the public comment and testimony is received and analyzed, the ARMP is completed and approved by the tribal government. The approved ARMP is sent to the Secretary of Interior, BIA agency superintendent, or regional director for review. The Bureau of Indian Affairs is responsible to notify lessees, permittees, beneficial owners about the tribal rule. It's not the tribe's responsibility to notify lessees, permittees, and beneficial owners of the tribal rule. It's the Bureau of Indian Affairs. Conservation plans. Secretary shall comply with tribal laws and ordinances. Indian Agricultural Lands Trespass. It's a collection of the values of the products illegally used or removed, plus a penalty of double their values. So if one AUM is removed and the AUM is worth $23, it's $23 plus the double value. So it'd be 46 plus 23. So that'd be 69. Collection of the costs associated with damage to the Indian agricultural lands caused by the act of trespass, and a collection of the costs associated with enforcement of the regulations. So I was involved with Leachman Cattle Company had 840 or 800 plus horses in trespass on the Crow Reservation. In 2011, Crow Tribe contracted with the Crow Agency, Bureau of Indian Affairs, and gathered 800 plus horses, and we sold them over a 3-day weekend at the Leachman headquarters. I think the trespass penalties against Leachman was over $300,000. It's a lot of work. It takes a lot of documentation. I was a team leader for the Indian Agricultural Lands Trespass regulation development. There has been several Interior Board of Indian Appeals administrative decisions since the regulations were approved. The penalties have to be reasonable and prudent, which means that there is a basis for the penalty. All trespass investigations need to be documented, and letters must be sent within 5 business days after trespass is discovered, or another field inspection must be completed. Indian Agricultural Lands Trespass is a continuing issue, whether it is illegal dumping, feral horses, illegal housing, unauthorized trails. Tribal staff must document. So one of the big parts of American Indian Agricultural Resource Management Act is the assessment, Part 3714, assessment of Indian agricultural management programs. This has never been funded, ever. Secretary, in consultation with affected tribes, enter into contract with non-federal entity, conduct independent assessment of agricultural land management and practices, pair with federal management and federally served private lands. In this case, federally served private lands means funding for NRCS, FSA. The purpose was to decide what needs to be done to improve the condition of Indian agricultural lands, identify obstacles to Indian access to federal or private programs. So now I'm going to start talking about the federal budget process. So we're in the middle of the 2019 fiscal year for the federal government. It ends September 30th of 2019. The Green Book's already out. It shows the funding and discusses the funding levels for, and that's a typo, should be for fiscal year 2020. And the federal agencies are already preparing the request for the budget year, and they've had public testimony already. Tribal government options, lobby congressional delegation. So what the process has been, and it's probably changed since I retired, but there was 2 reps from each region that represented the tribal interests. Each region, tribal participants in each region got to determine 5 to 10 regional tribal priorities. So they go to DC and they have 15 minutes to make a presentation. Most people can't even clear their throats in 15 minutes. Priorities are usually education, law enforcement, aid to tribal government, and tribal courts and social services. Last week, Assistant Secretary of Indian Affairs Tara Sweeney testified in front of the Senate committee. So basically what the president's budget says is no net growth. So if Department of Interior has $10 billion and the president says they want a 10% cut, so that means they have to cut $1 billion, and therefore the total budget for Department of Interior cannot exceed $9 billion. So zero balance means that they have to stay within the boundaries of the president's budget. Tribes need to lobby Congress to effect change in budgets for conservation. So here's what it is for 2020. For the BIA Trust, Natural Resource Management, $73 million. So one of the line items in the budget for natural resources is natural resources, and that's a tribal priority allocation. The tribal priority allocations were started back in the mid 80s. And so the budget was given to the tribe like in February, and then they had the authority to move money from one tribal priority to another. And so as time moved along, they kept shifting money from natural resources to social services or education or law enforcement. The other 5 line items are basically administrative authorities within the Bureau of Indian Affairs to decide where the money goes. There's really no tribal priority. The scope of BI programs is broader than that of any other federal agency. It is extensive and covers virtually the entire range of state, local, and tribal government services, including elementary, secondary, and post-secondary education, social services, law enforcement, tribal justice systems, business loans, land and airship records, tribal government support, forestry, agricultural, rangeland development, water resources, fish, wildlife, and parks, roads, housing, adult and juvenile detention facilities, and irrigation and power systems. And the slide that we're on, although the not in bold programs are included in natural resource management, only natural resources is actually a tribal priority allocation. The other programs are added as BI administrative allowances. So the branch of agriculture and range, which is a tribal priority allocation, is proposed budget for next year is 19.6 million, and then they added another 5.4 for invasive species management. That comes out to about 50 cents an acre. Here's the other BI trust programs. Forestry, there's 5.3 million acres. They get about $1.03 an acre. Water resources, 10.6. And then if you add in the irrigation operations and maintenance, the total budget for water resources and irrigation is 25 million. Fish, wildlife, and parks, 14.5. If you add in the discretionary accounts, it comes up to about 57 million. And then BI real estate services is 122 million. Tribes do not understand that they have the right to request from the Bureau of Indian Affairs on why and where the money is going for natural resource trust programs. So let's look at the rest of the Department of Interior. That's not all of it because National Parks isn't in here, and then there's USGS is not in here. Office of Special Trustee gets 105 million. U.S. Forest Service 5 billion, and that comes out to about $25, almost $26 an acre. BLM gets 1.1 billion, which comes out to be about $4.50 an acre. The Wild Horse and Burro Act gets almost 76 million. You go back to the BI Trust Natural Resources, 73 million. Bureau of Reclamation, 1.1 billion. Fish and Wildlife Service, 1.3 billion. And Wildland Fire, 1.1 billion. So there's not much parity. I think I left out the heading. So this is talking about individual leasing. Oh, here it goes. I must have cut it out. So we're gonna, it's leasing of Indian agricultural lands. We're gonna go back. So the Secretary is authorized to approve agricultural leases up to 10 years and up to 25 years if there's improvements that need to be made. And the continuation of that authority of secretary is when such longer tenure is determined by the secretary to be in the best interest of the Indian landowners, and when such lease or permit requires substantial investment in the development of lands or crops by the lessee. So in my opinion, that means that if you have a beginning farmer and rancher program which has been established by the tribe, that the tribe has the right to grant longer tenures just because it takes longer for a new beginning farmer rancher to get their feet on the ground and get established. Authority of the tribe can provide a preference to Indian operators, and the tribe can define what a highly fractionated undivided heirship land is. The tribe can adopt an alternative plan for providing notice to owners and may waive or modify any general notice requirement of federal law and proceed to negotiate and lease or permit highly fractionated undivided interest airships in conformity with tribal land or tribal law in order to prevent waste and ensure income. As far as I know, no tribe has exercised their authority in defining what highly fractionated heirship land is. And nothing in this act shall be construed as limiting or altering the authority or right of individual lottees or Indian tribes in the legal or beneficial use of their Indian agricultural lands. The owners of a majority interest in any trust are authorized to enter into an ag lease, and such lease shall be binding upon the owners of the minority. The definition of majority is greater than 50%. And if the tribe has a rule like we talked about before, the majority interest of an individual tract or tracts can opt out of the tribal rule. And as far as I know, nobody's ever done it. So if the tribe would adopt a rule on highly fractionated interest, 50% of the beneficial owners must object in writing to the superintendent that they want to be not bound by the tribal rule on highly fractionated interests. A big section of the American Indian Agricultural Resource Management Act is Indian and Alaska Native Agricultural Management Education Assistance Programs. This has never been funded, ever. So now we're going to slowly get through the end of this. Planning and following the game plan to affect change. Plan short term, 1 to 3 years, longer term, 4 to 10 years. Implement the plan, monitor and replan. When you do planning, you should include all of the stakeholders. Lessees, permittees, tribal committees and programs, landowners, federal agencies, nonprofit organizations. Provide notice of planning progress, stage, implementation, success and failures. When you're dealing with your partners, the rule of 3 is the best. Wait for at least 3 people to provide their input before you continue. Today's society, it's instant gratification. I say something, you say something, I say something back. It's important to engage, listen, restate their position in your own words so you can comprehend what their intent and reasoning may be. This may also allow them to hear what you have heard. Their issue may be a tribal council issue. As we've demonstrated in the webinar, the tribe has to lift the heavy loads. The tribes have to make the decisions. The tribes have to determine their self-determination. Request a solution from your partners. We're all in this together. I have to love you, but I don't have to like you. I used to volunteer at a food bank, and it was at a Catholic church, and one of our volunteers was very loud, very obnoxious. And the priest came over to him one day and he said, "John, I have to love you, but I don't have to like you." He didn't say Allan. Tribal options and opportunities. Determine the resource need. Determine funding to resolve the issues. Determine the tribal contact. Make sure you have somebody in the tribal government or tribal staff that people can go to for further information. Pass a resolution requesting funding. If you never ask for the money, you'll never get funded. Send your funding request to state's congressional delegation, the appropriate congressional committee, and the Department of Interior leadership, including your BI superintendent and your regional director. And Darrell Account. He's the director of the Bureau of Indian Affairs, and Tara Sweeney is the Assistant Secretary of Indian Affairs. Prepare a one-page issues paper for tribal leadership to lobby Congress and Department of Interior. Make sure they understand what's on the piece of paper, because staffers, congressional staffers will be asking for information, especially determine the tribal contacts, so if they need further information, they can contact somebody in the tribe. Here's the United States Senate Committee on Indian Affairs. That's my dog, Soshi. Here's the United States House Committee on Natural Resources. There's about 30 members, and I only put the top 3 on there. If you have any questions, please send me an email. This is my cell phone number. You can text me, you can call me. I'll answer to the best of my ability. I appreciate your attendance, and I hope you learned something. And I appreciate my opportunity with INCA.